Hello, I'm Tommy Preston, and I'm the Chief Talent Officer for the Boeing Company. I also have the honor of serving as the 2025 National Law Day Chair for the American Bar Association. I want to welcome you to today's Law Day program, conducted in partnership with the Law Library of Congress. I also want to offer a tremendous thank you to our partners at the Law Library of Congress for their collaboration in planning and leading this program. We have a great discussion planned for you today. Law Day is an annual celebration formally recognized on May 1st to reflect on the rule of law and the role of the legal system in supporting America's democracy and representative government. Law Day was first observed nationally through an act of Congress signed by President Dwight Eisenhower in 1958. I encourage you to visit our website, www.lawday.org, for more information. This year's Law Day theme is the Constitution's promise, out of many, one. Our Constitution establishes a framework for government that unites us as one, e pluribus unum. But this isn't strictly an American idea. Today's program will explore how law, specifically law spelled out in constitutions, affects unity all around the world. The moderator for today's discussion is Alejandro Ponce. Dr. Ponce is the executive director of the World Justice Project, leading its global efforts to advance the rule of law through research, data-driven insights, and strategic initiatives. He is a trained economist and played a key role in developing the World Justice Project's Rule of Law Index in 2012, which was the first major initiative to quantify the global justice gap. Now I'll turn the program over to Dr. Ponce. I hope you all enjoy this program, and thank you again for joining us. Over to you, Dr. Ponce.
Thank you very much for the kind invitation, and welcome everyone for joining us today. It's a pleasure to be part of this important conversation. This session is going to bring together three distinct but deeply connected perspectives on the enduring importance of constitutionalism and the rule of law in uniting societies. On one hand, as we heard, constitutions set out fundamental rules that guide how countries govern. They define the power of the institutions, protect individual rights, and establish really the rules of the game. And obviously, when those rules and values are preferred or are really reflect the preference of the population, people are more likely to follow them and see them as legitimate. And obviously, this has an impact. This strengthens the social contract and help build trust between citizens and the state. On the other hand, the rule of law ensures that these rules are applied fairly and consistently, and that everyone, including the state, is held accountable under the law. So as I said, a society that is governed by the rule of law protects individual rights, limits the abuses of power, and ultimately ensures access to justice for everyone. And when both of those principles are upheld, they contribute to social inclusion and a shared sense of unity and identity and stronger democratic values. In recent years, however, something that we have seen is that the adherence to the rule of law has declined worldwide. According to the data that we collect at the World Justice Project, in 2024, more than 61% of countries showed a decline in the global score of rule of law. And this is a trend that we have seen over several years already. Even though that trend has declined, still we see more countries declining in the rule of law scores than improving. And obviously this is due to erosion of checks and balances, fundamental rights, and access to justice. And this erosion can threaten the social contract and ultimately undermine democratic values. And that's the focus that we will have in the conversation today. We're fortunate to have three outstanding panelists with us. So first, we're going to hear from Professor Sellers. He is the Regents Professor at the University System of Maryland and Director of the University of Baltimore Center for International and Comparative Law. He has authored more than 15 books and numerous articles, and he also serves in leadership roles, including President-elect of the American Society of Comparative Law. Next, we're going to hear from Tariq Ahmad. a senior foreign law specialist at the Law Library of Congress, where he focuses on South Asian common law jurisdictions, especially India and Pakistan. His research has a special emphasis on religion and law in the region, and he has law degrees from the University of College London and American University Washington College of Law. And finally, we'll hear from Dr. Elkins. So he's a professor at the University of Texas. His research centers on democracy, constitutional design, and institutional reform, with particular emphasis in Latin America. And he co-directs the Comparative Constitutional Projects and the Constitute website, both designed to support constitutional development in new democracies. First, Professor Sellers will open with a broad conceptual and historical framing, highlighting the rule of law as a timeless, non-partisan root in US constitutional history, and more broadly in global democratic development. Then Tariq is going to examine India's constitutional debates on secularism and invocation of the divine, showing how contested language has shaped national unity in India. And finally, Dr. Elkins will explore the US public attitudes toward constitutional reform, offering comparative insights into the culture of amendments and the role of the public engagement in constitutional evolution. So obviously together, these presentations provide a rich foundation that really reflect the links between unity, constitutionalism, and the rule of law across time and geographies. So again, I mean, today's session is not only about an individual country, but it's more about experiences that different countries have had or have experienced in building these institutions and these shared principles. So to begin, I'm going to pass the floor to Professor Sellers, who is going to talk about the timeless value of the rule of law. And of course, just to begin, the first question is if he can kick us off just by explaining what we mean by the rule of law, how this concept has evolved historically, and what makes so fundamentally that the Congress and the American Bar Association have chosen to dedicate a day to celebrate its importance. So, Professor Sellers, the floor is yours.
So thank you very much, Alejandro, for that question. Why did Congress and the ABA set aside a special day every year to celebrate the rule of law? And could I have my first slide? So the short answer to that question is the rule of law is the only way that any society can have equal justice under law. So what you're looking at here is the pediment of the Supreme Court of the United States declaring, in effect, the mission of that enterprise, equal justice under law. You can't have equal justice under law. You can't have liberty and justice for all, as we say in our Pledge of Allegiance. You can't have one nation indivisible with liberty and justice for all, unless you have the rule of law. So in its preamble, the Constitution of the United States of America sets out its purposes, sets out the purposes for which our Constitution is written. And these are purposes which I personally completely share and endorse. And the purpose of our republic, these purposes, which are wonderful purposes, are to form a more perfect union, to establish justice, to promote the general welfare, and to secure the blessings of liberty to ourselves and to our prosperity. And these are the founding purposes and principles of the United States of America, which we should all embrace. And these are the first principles and the first words of our Constitution. So we, the people, ordained and established the Constitution of the United States precisely in order to establish justice through the rule of law. So that's why in 1961, the Congress of the United States, it's now installed in the United States Code, 36 U.S. Code 113, the Congress of the United States established Law Day so that we, they said, can rededicate ourselves, as Congress put it, rededicate ourselves to the ideals of equality and justice under law. Congress said we should do so both in our relations with each other, but also in our relations with other countries. So equality and justice under law, both in our relations with each other, that's domestic law, domestic civil law, and in our relations with other countries, and that's international law. So in 1961, in the wake of the Second World War, at the outset of the civil rights movement, the United States Congress wanted us to rededicate ourselves to the commitments of the founders of our republic, both within the United States, a commitment to the rule of law within the United States, and to the global rule of law, which we helped to establish, which we, the United States of America, helped to establish and restore with our victory in the Second World War. Could I have the second image, please? So this slide brings me back to the American Bar Association and to President Eisenhower and to the meaning of the rule of law, which is equal justice under law. Because the idea of Law Day was a project of the American Bar Association before it was adopted and endorsed by the United States Congress. And it was promoted by President Eisenhower, who announced the first Law Day in 1958 at the suggestion of the American Bar Association to celebrate the principles of just and equal government under law. And that's the heart of the rule of law. And it is the moral foundation of the United States of America. And it is the basis of the Constitution of the United States, that government itself should be under the law. In other words, that the government, like all of us, should be subject to the law. So let me tell you a story. In the year 2000, the millennium, I was living in The Hague, working at the Peace Palace in The Hague. I was working at the Academy of International Law. And my daughter was going to school in The Hague and was on the cross-country team. So she went to the league championship race for all the European schools, which was in Windsor Great Park in Surrey. And my wife and I were tramping through the rain, watching the girls slosh through the mud across the countryside. And through the mist in the English countryside, through the rainy mist, we saw a temple. And it's this temple, a little marble Tholos temple. And we took shelter there from the rain, and we studied the inscriptions to see what on earth this was. And the inscription said, erected by the American Bar Association. It was a temple to Magna Carta. It's actually on the very spot where King John conceded the Great Charter to the barons of England on June 12th, 1215 AD, 800 years ago. And we, the American Bar Association, American lawyers, venerate and celebrate equal freedom under law at Runnymede, because that's where this was. It turns out it's Runnymede. Runnymede means wet, muddy meadow, and that's what it still is. But American lawyers trace our rule of law commitment back 800 years through British history, all the way to this moment in Runnymede. Could I have the next slide, please? So this is a picture of the scene where King John conceded the Magna Carta 800 years ago. And what he conceded was that no person can be dispossessed of their life, their liberty, or their property without due process of law. The very same protections that we have in the United States Constitution in the 5th and 14th Amendments. No person shall be deprived, no person, it's not restricted in any way by citizenship or anything, no person shall be denied life, liberty, or property without due process of law. So just to finish the story, the temple at Runnymede was erected by the ABA under President Eisenhower to commemorate a set of values, the rule of law, that are fundamental to the United States, but also to Britain and also to France and also actually to all the victorious allies in the Second World War. And that was really our uniting values in that conflict, whether we would tolerate lawless behavior in international relations or not. And we embodied those values not only in the United States Constitution, but also in the United Nations Charter, another great charter, which set out to establish justice, and I'm quoting now from that charter, to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women and of nations, large and small. The point is that we, the people of the United Nations, in the United Nations Charter, could I have another slide, please? So just like just like we, the people of the United States, in the United States Constitution, the purpose of the United Nations is to establish justice, to create a social order. This is the International Court of Justice in The Hague. I would have liked to have, I couldn't get a good picture with all the judges in their beautiful outfits, but there's a beautiful array of judges if you go there and watch them sit. But the purpose of the whole enterprise is to establish justice, to create a social order in which all people and all peoples can enjoy their rights, in which all people and all persons can enjoy security, safety, dignity, and respect. And this is only possible when we have the rule of law. Whereas the founders of our own Constitution put it, they called it the empire of laws and not of men. Not the rule of men, but the rule of law. And so the kings, beginning with King John, the kings and all magistrates were placed below the law. So this is 800 years ago. Already we had established this principle. Could I have the next slide? So this is the entrance to Harvard Law School. Non sub homine sed sub Deo et lege, not below men, but below God and the law. And this is a quotation from Bracton, a 13th century British author. So Law Day was created by the American Bar Association and then the United States Congress to remind us of our founding principles. The United States is a republic of laws and not of arbitrary power. Nobody should be deprived of life, liberty, or property without due process of law. We all have the right to dignity and to fundamental rights. We all have the right to security. We all have the right to privacy. We all have the right to self-determination. And this is as true of our relationship with the world as it is within the United States. The project of our republic has been to establish justice, to serve the general welfare, and to secure liberty for all. And this can only be done through the rule of law. So thank you, United States Congress, for reminding us of this. Thank you, American Bar Association. Thank you, Library of Congress. And thank you, all of you who care enough to celebrate with us. Thank you for your patience and attention. Thank you, Alejandro.
Thank you very much. Very helpful to set the stage of the value of the Constitution and the rule of law. Now we're going to give the floor to Tariq Ahmad. So Tariq, as we reflect on this day's theme, on unity and constitutionalism, I'd like to turn to you to the case of India. You have studied that. India constitutional secularism seeks to navigate one of the most religiously diverse societies. So can you walk us through the debates within the Constitutional Assembly over including terms like God, secular in the Constitution, which obviously could be quite contested in India, and how these debates reflect deeper questions about national unity, identity, and the evolving role of religion in India's constitutional order?
Thank you so much, Alejandro. Hello, everyone. As was already stated, as we kind of reflect on this year's Law Day theme, of constitutionalism and the vital role of constitutional design in bridging differences and fostering unity within nations, I'll be focusing on India's Constituent Assembly debates surrounding the preamble of India's constitution. In particular, I'll be exploring the assembly debates over whether to invoke God or the divine and whether to include the term secular in the preamble of India's constitution. These debates offer key insights into the contested nature of Indian secularism, its historical evolution, and the kind of ongoing judicial, academic, and political discourse and debates that continue to shape its interpretation today. Next slide, please. Here's the original form of the preamble of India's constitution as it stood when the Constitution of India first came into force. As you can see, it neither explicitly invokes God or the divine, nor does it expressly define India as a secular state. Next slide, please. Now, the Constituent Assembly was convened in December 1946 and was tasked to draft the Constitution of India. The drafting process spanned nearly 3 years, during which the Assembly held 11 sessions over 165 days. 114 of those days were devoted specifically to debating and deliberating the draft constitution. Now, the preamble was discussed during one of the Assembly's final sessions. The preamble was based on the objectives resolution, which was passed by the Assembly to provide basic principles and guiding framework for the drafting of the final constitution. Now, during the framing of the Indian Constitution, the Assembly engaged at times quite intense and contentious debates over secularism and whether to invoke God explicitly in the preamble. These discussions revealed the desire to balance and recognize, on the one hand, India's deeply religious society and heritage, and on the other, a concern for affirming secularism, religious freedom, minority rights, and the rights of both believers and non-believers. Ultimately, the Assembly decided to omit both the reference to God and the word secular. One of the major proposals came from H.V. Kamath, who moved an amendment to begin the preamble with the phrase, "in the name of God." However, this amendment was defeated by the Assembly. Kamath defended his proposal, arguing that religion was the voice of our ancient civilization and that invoking God in the preamble would simply reflect the spirit and the will of the Indian people. His stance, however, drew criticism from various members who felt that referencing God in the Constitution would undermine the principle of religious freedom and the freedom to not to believe, and that religion is a matter of individual choice and private affair. One member, Purnima Banerjee, even appealed to Kamath not to put us to the embarrassment of having to vote upon God. Pandit Kunzro, another member, strongly opposed the amendment, warning that such a reference would introduce narrow sectarian spirit, which would be contrary to the spirit of the Constitution. However, member Kamath remained steadfast in his position. And so another member, Rohini Kumar Chaudhary, remarked that if the Assembly were to invoke God, then it should also consider invoking the goddess. This suggestion reportedly elicited laughter from some of the members, but Chaudhary clarified that although he was not in favor of the amendment being proposed at all, if we bring the name of God, we should bring in the name of goddess, reflecting his own religious convictions. Seeking to attempt at a middle path, Govind Malavia proposed a different invocation. By the grace of Parameshwar, an epithet used for the supreme being and the supreme reality in the Hindu tradition, the supreme being, Lord of the universe, it invokes a term for the divine recognized by a significant majority of the population in India, while simultaneously seeking neutrality by acknowledging the supreme being is known by different names across different peoples in the country. He argued that it's not anti-secular, since it was clear that not any particular religion's God was being sanctified. However, this amendment also came under criticism for proposing something similar to what had already been rejected. The Assembly also considered explicitly inserting the term secular twice into the preamble, but this too was not adopted. An amendment was proposed to establish India as a secular cooperative commonwealth, but this particular amendment was rejected. However, it was rejected for the reference to socialism, and no direct discussion was used to the term of secular in relation to this amendment. Some members feared that adopting the term secular might be misinterpreted as a denial of the nation's religious heritage or being anti-religious. P.K. Sen, for example, argued that such thinking reflected a gross misconception. It is a gross misconception to think that all contact with God or religion has been abandoned. as if by calling secular democratic republic, it is actually becoming secular or godless. Others appear to feel that other provisions of the Constitution, like the right to religious freedom, already implied that secularism was a core feature of the Constitution. In the end, the Assembly decided to omit both God and secular from the original preamble, reflecting the framers' nuanced and kind of cautious approach, balancing their own secular ideals with the broader objective of building a pluralistic nation while trying not to offend their own deeply held religious beliefs. However, even in the beginning, it seems the secular framework they were attempting to devise was contested or reflected an inherent tension and continues to be a matter of fierce debate politically, judicially, and academically. Now I'm going to kind of touch upon and explore some of the academic theories and conceptions of secularism in India and how they relate to the original framers, but also how these conceptions have evolved through state and judicial practice. Western models of secularism emphasize strict separation between church and state in theory, either as a complete withdrawal of the state from religion, for example, in the form of a non-establishment clause or non-recognition of a state religion, or by limiting religion to the private sphere rather than the public sphere, or as a mutual withdrawal where neither can interfere in the matters of the other. Often the French and American models of secularism are referred to in this category. Certainly some of the framers of India's constitution espoused this view. K.T. Shah, who saw religion as a private affair between a person and his God, and is reflected in many of the ideas in the assembly debates. However, these Western models don't appear to have been adopted, as some of the framers like K.M. Munshi felt that India needed to evolve a characteristically Indian secularism. As Katrak and Kulkarni state in their paper, which is provided in this slide, religion is an integral part of the life of India, and secularism here must be reflective of India's unique social and religious experience. One theory that tries to explain this is proposed by Shafali Jha, which is the equal respect theory of secularism, also described as the Nehruvian conception of secularism, named after the first Prime Minister of India. Instead of separating state and religion, or the state staying away from all religions, the Indian state's goal is to respect all religions equally. K.M. Munshi, one of the members of the assembly, stated that we are a people of deeply religious moorings, and at the same time, we have a living tradition of tolerance. Therefore, there cannot be a state religion, but at the same time, there cannot be a rigid line drawn between state and religion. Some academics have criticized this theory for inadequately explaining the Indian state's differential treatments of religions in its regulatory and reform efforts, often citing examples of such as how historically more active reforms were in certain areas, like the reform of Hindu personal law, like example, the introduction of the right to divorce under Hindu law, and while there's been far less similar reforms under Muslim personal law historically. Now, Rajiv Bhargava formulates the principled distance model, which argues that the Indian state maintains a principled distance from religion. As the author describes it, this operates at the level of ends and institutions rather than through total disengagement or separation. This model allows the state to intervene in religious practices when necessary, such as in the interest of legal or social reform. It supports institutional separation from religion, no official state religion or no state religious functionaries, while also permitting the state to engage in legal reforms to challenge what the state believes are regressive religious practices, while still supporting religious freedoms. For example, banning untouchability and opening Hindu religious institutions and temples to all classes or sections for Hindus, including Dalits and women. Another example is the criminal ban on the practice of instant divorce by Muslim men, known as talaq al-biddat, where the husband could unilaterally or irrevocably divorce his wife by saying talaq 3 times in one sitting. Another conception is adopted by Rajiv Dhawan, conceived as a 3-component version of Indian secularism, which includes religious freedom, celebratory neutrality, and reformatory justice. Now, as Dr. Ronojoy Sen summarizes, this approach to religious freedom covers not just religious beliefs, but also rituals and practices. Celebratory neutrality entails a state that assists both financially and otherwise in the celebration of all states and all faiths. And another author writes that the state generally does not discriminate between them. Reformatory justice entails regulating and reforming religious institutions and practices, leaving the core elements that are beyond regulation. Now, the last theory that I wanted to touch upon is by Deepa Asavedo, who challenges the idea that the Indian state is truly secular. She argues that the desire to separate religion and state is integral to any understanding of secularism, and consequently, the Indian state neither is nor was meant to be truly secular or neutral. However, Asaveda also adds that Indian secularists correctly identify that the Indian state's distinctive approach to religion-state relations is appropriate to the Indian context and in keeping with India's constitutional goals. Now, one of the main examples the author gives to support this argument is the state's direct management and control of Hindu religious institutions and temples, and the state's effort to internally reform religion and religious practices. Other commentators also question the state's secular ethos when secular justifications are used to legitimize majoritarian persecution or more selective reform against minority communities. In recent years, the Indian state has seen more active role in reforming other practices of other religious groups as well. For example, we've seen, as I've already mentioned, the criminalization of triple talaq, the increased regulation of Waqf properties and Muslim institutions, among other controversial areas of reform. Now, the term secular was formally inserted into the preamble of the Indian Constitution through the 42nd Amendment in 1976, enacted during a highly controversial period in India's history. The amendment, often referred to as the mini constitution, was passed during the emergency period, a 21-month period when Prime Minister Indira Gandhi declared a national emergency, leading to the suspension of fundamental rights, press censorship, arrest of political opponents, and significant centralization of power. The amendment also curtailed the power of the judiciary, particularly by limiting its ability to review the constitutional validity of laws, among other sweeping changes. This amendment altered the description of India in the preamble from sovereign democratic republic to sovereign socialist secular democratic republic. Now, after the emergency ended following the 1977 general elections, the government in power sought to reverse several constitutional changes during the emergency and roll back some of the emergency era provisions, strengthening protections of fundamental rights and preventing the misuse of emergency powers. But however, the change to the preamble remained intact. Now, under another amendment, the 45th Amendment, there was a proposal to define secular republic as one that grants equal respect to all religions, but this proposal was never passed. Now, in the landmark case of Minerva Mill, the Supreme Court struck down many of the provisions of the 42nd Amendment for violating the basic structure doctrine, which we'll discuss a little bit later. However, the textual change to the preamble, specifically the addition of the words socialist and secular, were not addressed in the judgment and therefore remained in place. It was not until 2020, in the case of Dr. Balram Singh, that the legitimacy of the insertion of the word secular into the preamble was formally challenged in court, more than 4 decades after the amendment had been enacted. So this is the amended constitution as it is now. I think I will stop now and we can discuss the Supreme Court decision a bit later in the Q&A portion.
Thank you very much, Tariq. This is very interesting. And I want to then pass the floor to Professor Elkins. And building on the reflection that we just had from Tariq about constitutional principles and national identity, I'd like to turn the role to the public and the public engagement, particularly in shaping constitutional change. So you have a previous work, the culture of psychology of constitutional amendments in the US. And I want to ask you, what does your research reveal about how American thinks about changing the Constitution? And how does this compare, for example, with public attitudes and amendments in other countries? So the floor is yours.
Thank you, Alejandro. It really is a privilege and honor to be part of Law Day today. So I want to thank you and the other organizers for including me. And the short answer, Alejandro, is that I think the American public is surprisingly open to amending the US Constitution. And this is surprising in part because we think that a culture of non-amendment has really taken root. And I'm going to show you some data today that helps us understand that a little bit better. So next slide, if you would. A lot of this data is going to come from this project, the Comparative Constitutions Project, that I run with Tom Ginsberg, who's at the University of Chicago. And since 2005, we've been collecting the world's constitutions trying to understand what is in them. And next slide, please. You can imagine that this project involves first understanding when constitutions have been written, when they've been amended, collecting all the documents associated with these changes, and then, of course, understanding them across a whole bunch of topics. So I just want to give you a sense of like the US with respect to constitutional change in other places. This just gives you this area graph, gives you a sense of why constitutions are helpful, at least for scholars in terms of understanding the political hopes and dreams of different countries. So the top area represents the number of countries in the world, and the next line below that, those that have constitutions. So almost every constitution after country after 1900 has a constitution, which is helpful. And you can see our sample that we study here is the next area. So we have pretty much every constitution and its amendment in our data set. The bottom line is just one of the many provisions that we've covered. I'll talk about some of those a little bit in a second, but next slide, please. So, I mean, the first question is really how long do constitutions last? And this is what's called the survival curve. And this is just the probability that any constitution is still alive at a given age. The horizontal axis on the bottom, the label is obscured, but you can, that represents the age. And if you were to draw a vertical line and a horizontal line at the y-axis where we're at 0.5, which essentially represents the age at which constitutions, half of constitutions are still alive, you get a measure of life expectancy, which is 19 years, which is interesting and ironic, in part because Thomas Jefferson had famously suggested that every constitution self-destruct, and really every law self-destruct after 19 years. He thought after a generation, everything should be rewritten. And it just goes to show that as a positive matter, that's when most constitutions are expected to live, which is interesting. Next curve, please. Next slide, please. If you take the slope of that previous line, you get what is something like the rate at which constitutions die at a given age. And this is interesting in part because it helps us understand when constitutions are expected to live. This is ironically very much like the hazard plot for marriage. And of course, constitutions ever since Lincoln have been compared to marriage. Both are covenants to bring together a union of disparate people, and they're supposed to last forever. And of course, we know how that goes. But in the hazard graph for marriage looks exactly like this. There's a period of risk at about 7 years, and then again about 20 years, presumably after the kids go off to college. But after that, if the marriage is still going, it's essentially there forever. And this is exactly the case for constitutions, which is really interesting. It explains what's going on with the US. We've blasted past these really high risk areas or points in our law. And it's been not only almost immutable, but also unamendable. So next slide, please. The thought then is that, and by the way, this varies across countries. This is just a great chart that the New York Times data analyst made with our data, and high bars for each of these countries represent a new constitution, and the darker, smaller bars are amendments. And so you can see there's not a lot of dark bars. Next slide. But if you go, and this is Western Europe, if you go to Latin America, quite a few other, which is a region that's had a lot more instability in terms of its constitutions, a lot of change. And so next slide, please. Just to take 3 of these countries, the US, you can see one constitution if you don't count the Articles of Confederation, and 27 amendments. Next slide. France, you might know the old joke about somebody comes into the library and asks for a copy of the French Constitution only to be told that they don't stock periodicals. It's had 7 or 8 constitutions, so seems like a less stable place constitutionally, or at least with a lot more constitutional systems. But next slide, nothing like the Dominican Republic, which has had about 30 over its 200-year life. And incidentally, its neighbor on the island of Hispaniola, Haiti, had a similar number. So together, these two countries, or that island, I should say, represents about 1/10 of the world's constitutions. So the place to go study constitutions. But next slide, please. You would think that the lack of change in the US, a single constitution that hasn't been amended very often, would lead to an amendment culture such that people are not open to change, not open to any reform proposals, and have essentially deferred to the Supreme Court to adjudicate the higher law. It's interesting. So Jill Lepore and I tried to test this a little bit. So she has a project. She's an historian at Harvard. Has a project in which she's collected every single proposal, formal proposal to amend the U.S. Constitution. And there are about 12,000 that have made it to Congress. And as you can see, the bars here represent the number of proposals per year, and there's a high point in the early 1970s when there were a lot of proposals. But you can see in general, there are quite a few. And I think this is one piece of data that leads us to believe that there's a latent desire for some reform, or at least thinking to some amendment or another to the US Constitution. I mean, obviously, many of these are in vain. Almost all of these are in vain. And so it sort of defines Einstein's definition of insanity. But, there is still at least the effort. Next slide, please. By the way, she and her team have also done this for petitions. Of course, the right to petition is a very famous part of the US Constitution, and there are a lot of formal petitions, many of them about constitutional amendments. And so, again, another piece of evidence suggesting kind of a reform effort at heart. So she and I have, it's interesting to think about what these amendment proposals are about. She and I have tagged them with the topics from the Comparative Constitutions Project. So if you recall, we code constitutions in our Comparative Constitutions Project for some 350 topics, and we've coded her data set of amendment proposals with the same topics. This is, by the way, an example of an historian in her part and a political scientist, me, working together. And as you might know, historians and political scientists are famously at odds. But so I think this bodes well for across these two different disciplines. But anyway, you can see what most of these are about. Of course, there were many proposals to get the ERA on the books, which failed. Others you can see about the vice president, which was often caught up in amendments or proposal amendments about his or her selection and efforts of questions of succession, among others. But you can see the other ones as well. Next slide, please. This is really interesting. And I mentioned these are the topics that we use to code constitutions. And this is all, as Alejandro mentioned, all out there on a website that we put together with Google in 2013. And this is essentially an indexed repository of the world's constitutions, indexed with these 350 topics. And we're, next slide, please. Very cognizant of the fact that people are writing constitutions with this set of indexed constitutions. And so the topics that we code them with have to be up to date, only because when people think about what should be in a constitution in one of these assemblies or writing groups, they're using our website. So we're really careful about that. And I just want to call attention to the Library of Congress, which has been wonderful in its own way in obviously cataloging the world's books over the years. And our effort is in some ways an ontology or taxonomy or controlled vocabulary, very similar to what the Library of Congress has done. And it's K-class librarian Yolanda Goldberg, who has kind of single-handedly done all the law classifications for the Library of Congress over the last 50 years. Anyway, that's a lot of what I'm involved in right now. Medicine and biology have a strict taxonomy in which they represent those ideas and those disciplines, but comparative law doesn't. And this is kind of an effort on our part to keep up with the ideas that are in constitutions. Okay, next slide. I promised that I would talk about what the American public think about amendments. And in addition to thinking about petitions and formal proposals, there have been a lot of public opinion questions out there, just directly asking people, would you be in favor of a certain proposal or not? And that middle violin plot, one that says USA 1937 to 1921. These are a set of 624 questions about various sets of proposals to amend the US constitutions. And this is just plotting the distribution of the percent in favor of that proposal. So you can see on average, it's over 50%. So on average, depending on the proposal, of course, Americans are open to change. We compared this to, we collected some data on where you says world 1815 to 2016. These are a set of 200 or so referenda on amendments to world constitutions, which almost always pass, as you can see. So it's not that different from what the American public are saying. It's helpful to have a reference point to see how the US number compares to others. And that's at least one interesting reference point. On the bottom, of course, in the US, we do not have public referendum on amendments to reform the US Constitution, but in the states we do. In Texas, my state has quite a few, about 10 every 2 years or so. So we'll have another 10 amendments to the Texas Constitution. And in general, those almost always pass. So, the US public opinion data that Lepore and I are analyzing are not too different from what people say in the world when actually asked to approve. Generally, the default strategy of people is to say yes. Okay, next slide. This depends a little bit on the proposal. Here are just some distributional plots of, again, the percentage in favor of a particular amendment. Legislative term limits, always very popular, high degree of consensus. Head of state selection, that's mostly about just doing away with the Electoral College, very popular as well. Equality regardless of gender, of course, is the ERA votes, a little bit closer to 50%. The only one that's below of all the proposals that we analyzed here was one about abortion. Of course, the country's famously divided on that. And the balanced budget is one, as you saw, it was like the fourth most proposed amendment in the US Congress, and it's always very popular. Next slide. This is really interesting over time. So for example, equal rights, the ERA had a lot of variation in its popularity while it was being contested in the 70s and early 80s. But after, of course, it was expired and no longer actually viable, there was a lot of consensus about it. The opposite of the Electoral College, which early on there was a high degree of consensus that the American public would want to do away with it, but since then, for reasons I could explain later, it's become less palatable, that amendment. Okay, next slide. Next slide. We can get to this in the Q&A. This has to do with what happens to amendments after they're passed and their popularity. But I want to go back to the ERA for a second and relate that to the balanced budget. One thing we saw with the ERA was that it was controversial as it was being discussed and as there was a national conversation about the ERA. And this is in part because once the public starts talking about an amendment, there are all sorts of counter arguments and considerations that come up. And one way to simulate this is to ask people's opinion of a proposal and then provide some counter arguments or at least some other considerations. And so a lot of the public opinion questions about the balanced budget do so. So you have a set, and this is the violin plot at the bottom there, which essentially asks, okay, are you in favor of a balanced budget amendment? And pretty much everybody says yes. But if you also say, listen, are you in favor of a balanced budget amendment if, for example, it means that Social Security would be affected? Well, then you have approval rates are a lot lower. And so this is in some ways a better simulation of what's involved once you have real deliberation about reform. Okay, next slide, please. I think I'm wrapping up here. Yes, final slide. One thing that Jill and I wanted to do was we mounted a survey, and of course we analyzed public opinion surveys over the last 70, 80 years, but we also wanted to ask our own and ask a few questions about not only you want to think not only about in the past whether people were amenable to change, but looking towards a potential constitutional convention, what they would want. And so one question we asked had to do with sort of the cornerstone features of the US Constitution, and ask them sort of what aspects, these are most of the features on this list are controversial, or at least political scientists and legal scholars have found them to be reputedly suboptimal aspects of the US Constitution. And so the question was, okay, what does the US public think? How committed are they to some of these features? And of course, the first one, right to vote, is not even something that's in the US Constitution, but a lot of people see it as a cornerstone. And of course, freedom of speech, not surprisingly. One of the key parts of the bargain in 1787 was equal representation of states. The US public not committed to that necessarily. 60% see it as a cornerstone feature. The next one is really interesting. About half the public could see us adopting parliamentarism over presidentialism. That is, over a directly elected president. And there are some other interesting aspects, all which have sort of low approval rates, as you can see going down. The bottom, which you may not be able to read, is life tenure for justice, and that's 21% thinking that that is a cornerstone feature of the US Constitution. Of course, that is one of the features that enshrines judicial independence to some degree, but apparently not a lot of commitment around the American public. Okay, that's a lot of data to digest. I think I'm going to leave it there. I think the concluding thought really is that the American public, despite what we might think about kind of an anti-amendment culture, is somewhat open to the idea of amendment, at least for certain provisions and certain features. Thank you.
Thank you very much. So, a lot of very interesting data, very ambitious project, an excellent project. So, and I think this is a very good way to transition to a discussion. I have some questions that I would like to ask you. So first, I think that one of the core elements of constitutions is that they set the rules just of what people can do. I mean, the government, just the role of different institutions and so on. So, but we also see that, constitutions have changed a lot, and just for a lot of different reasons with a lot of different topics. So, but I want to ask a question, and this links to the different discussions that we have had. So how can constitutions encourage unity? So, and why is this relevant? So can you just give us some reflections on this, please? Whoever wants to take it.
Sure, I'll take it. I think that it's a great question, because that's what they're seeking to do. You're trying to create a single unified state. So it's one of the main purposes of having constitutions, is to create unity. And I think that the way it can be most effectively done is by well stating principles that everyone can attach value to. So the United States has historically been famous for its effectiveness in getting Americans to consider themselves as being people who share fundamental principles. In other words, the Constitution has been the basis of our unity, not race, not religion, not language, but values. And I think if you can do that well, that's how you get unity. Otherwise, in other words, if you try to build unity, let's say around religion or race or anything else, you're going to find within your population natural divisions. There are going to be people who are excluded, and those people will be oppressed and not happy. But if you have good values, well articulated, that is a vehicle for unity. And I think the most effective constitutions have been the constitutions that stood for something. And I think that's the beauty of the US Constitution. I actually think that's the purpose of Law Day. The purpose of Law Day is to remind us of what our Constitution stands for, and thereby unify us. So I think values and principles are how you do it with a well-drafted Constitution.
Alejandro, I think Mortimer is exactly right. If I may just add a couple of thoughts to that. One thing that I think we've all been thinking a little bit about is how constitutions can stitch disparate people together. And I think Mortimer is exactly right that some of the broad principles that we can all rally around serve exactly that purpose. And I think when I've looked at world constitutions that don't do that, there are some interesting things that stick out. So some constitutions have what I would call strong identity regimes. They have an official religion or official language or a very strict high bar to citizenship. And those are hard because what is an official religion or official language clause doing in a constitution but telling somebody who's not that language or that religion that they are somehow a second-class member of the society? And this is something that the US Constitution does not do, which I think is one of the uniting elements of it. And one thing that a colleague and I have been doing is collect data on what we call the attachment gap between minorities in a country and the majority population. And so there's some obviously war-torn and balkanized places in which the minorities not particularly happy to be part of that country, and will express low levels of, for example, pride in the country compared to the majority group. And what's interesting about the US is when you compare minority citizens to majority citizens, there's plenty of division in the US, of course, but one thing you note is that there's very little attachment gap to the United States as a country. Both groups, or minority groups and majority groups, express similar levels of pride in the country. And I think part of this is not having a strong identity regime, but having elements of our Constitution and our legal structure, which are not structured along the lines of identity. And this is something that Tariq's discussion of India brings home, I think, particularly well.
Thank you. Indeed, I mean, this is a great point, and I want to ask Tariq precisely about what has happened. I mean, we heard, and linking it to this last point, with the introduction of the secular term in the amendment in India. And if we fast forward, just given all the discussions that the India had when they were building their constitution, so I would like to know just how does that discussion, and particularly the insertion of the secular term, remains relevant in present-day India in terms of jurisprudence, political discourse, and so on?
Yes, definitely. If you can turn to slide 17, I think that'll be helpful. So the Indian Supreme Court has consistently held in its jurisprudence that secularism is a basic feature of the Constitution, both before and after the 14th Second Amendment. In a landmark case in 1973, the court laid down that the basic structure doctrine, meaning that the power of Parliament to amend the Constitution is not unlimited. There exists a basic structure that cannot be altered, and that the court has the authority to strike down constitutional amendments that threaten this structure. Now, the court explicitly included the secular character of the Constitution as one of the such essential and unamendable features. Now, although the 42nd Amendment inserted the word secular into the preamble, the Supreme Court affirmed in another decision in 1994 that secularism was not a new principle introduced by the amendment, but was embedded in the Constitution from the very beginning. What was implicit, the court says, was made explicit. As previously noted, the insertion of the term secular in the preamble was not formally challenged until nearly 40 years later, and this is the Balram Singh case. So in 2020, a number of writ petitions were submitted to seek to remove the term secular from the preamble. These writ petitions were rejected by the Supreme Court. The petitioners argued that the kind of retrospective application of the amendment created a false impression that these principles were part of the Constitution since its inception. And they also argued that the Assembly had deliberately excluded the term and that the 42nd Amendment was enacted during a time of emergency, which made it unconstitutional. And since there was no democratic will of the people to sanction the amendment, they felt that that was unconstitutional. But in its 2024 ruling, the court acknowledged that though the Assembly had opted not to include the term in the original preamble, they emphasize that the constitution is a living document and that India's understanding of secularism has evolved over time. The term secular had earlier been seen by scholars and jurists as being imprecise and sometimes implying opposition to religion, but India over time has developed its own model of secularism where the state neither supports any religion nor penalizes the profession of any practice or faith. Next slide. So here in the 2024 ruling, the Supreme Court reaffirmed India's secular character as being integral to its constitutional identity. The court also clarified that since there's no official state religion and that all individuals enjoy equal rights to freedom of conscience and ability to profess, practice, and propagate their religion, the inclusion of the term secular in the preamble doesn't prohibit the state from reforming or eliminating religiously rooted practices that conflict with public interest and the right to equality. The court emphasized that secularism was a facet of the right to equality and was deeply woven within the Constitution's basic structure.
Thank you, Tariq. So I want to, for the discussion, the other big element that we have in our conversation is rule of law. So I want to go back to that term and ask you first to begin, what is the relationship between rule of law and constitutionalism? So whoever wants to respond.
Well, I'm always happy to speak, but I went first last time.
It's a big question, so yeah. Please go ahead.
Well, I guess I'll say that the same project, constitutionalism is born of an ambition to have the rule of law. Because this concept of the rule of I guess we should distinguish, because this is something that is important to be done. I gave a lecture once to the Constitutional Court of Russia on the rule of law. And they had a big book, and in the front of the book, there was a quote from me, and I asked someone to translate it back to English from Russian. And it was the opposite of what I believe. So people get confused and think sometimes of what I would call the rule by law, and use that to mean what I would call the rule of, in other words, the rule of law is the attempt to control power through law. The idea that even those with power should be under the law. Rule by law is a vehicle through which powerful people oppress other people using legalism. So what we're trying to create is what the founders of our Constitution called the empire of law, not the empire of men. And that means you need some kind of structure for making decisions that doesn't put it all in the hands of one or a few or give anyone unchecked power. And that's our Constitution particularly, which was very influential on the rest of the world, was drafted with that purpose. The purpose of figuring out how to actually have government that's powerful enough to do good things and make good decisions, but at the same time controlled by objective values. So the rule of law exists in service to fundamental values. And the most fundamental of those values is justice. Which was understood by our framers as meaning a world in which all people can live, all citizens, everyone under the rule of the law is taken into account and no one is oppressed. So it's a very noble desire, and I think it can only be achieved through constitutionalism. So without constitutionalism, there can be no rule of law. And that's why we bring these two things together.
Building on this, and you were mentioning just one of the basic principles of rule of law is to limit the power of authority, or to limit the abuse of power. And obviously one of the elements that all countries and different constitutions achieve or aim to achieve this is through the division of powers and checks and balances. So I would like to ask you first, a question. Just we know that in many countries we have different bodies, just independent judiciaries, executive, legislative. And first, if there is an imbalance, because each one of them have different goals, and many of those goals indeed check the other. So is there a fundamental imbalance of power in democracies among all these three branches? And second, to link it to the issue of constitutions, whether there are some things that constitutions indeed can do to achieve a better balance.
Well, I can start, Alejandro. I think that I think one way to think about it is, in terms of better balance or not, is to what goals are we trying to maximize to begin with? Because I think there are a lot of tensions in democracy, and one important tension is between, say, governance and getting things done as against representation, and they cut against one another. And if you're a society that wants to maximize representation, you might be okay about sacrificing governance and having some dysfunction. And um, on the other hand, if you're a society that's really struggling to get things done with respect to some of the major issues that confront the society, whether it be um, climate change, public health, public security, you name it, if your national government is really having a hard time deliberating and making decisions efficiently about those, um, then maybe dispensing with some of these Madisonian checks and balances, which provide a lot of friction and a lot of representation of even small minority groups, and I don't mean that mean ethnic minorities, I mean just minority groups more generally. If if your society is in facing these dire needs and decisions, then I think dispensing with a little representation makes sense. And so I think first and foremost, before we think about the better balance, like, what does your society want to maximize? And it seems to me that a lot of national governments are having a hard time reaching decisions about some of the major issues of the day, whether it's how to manage privacy and the internet, um, how to deal with um, rapidly changing technology, how to deal with a healthcare system that's just changing radically, and you name it, everything else. And so I think a little more efficiency might make sense. And I think a lot of societies have found that something like parliamentarism, which of course every political scientist loves, I think it's probably the case that 95% of political scientists would advocate a parliamentary system right now for most countries. And I think it does make sense to have a head of government selected directly by the legislature, so they can work hand in hand and they can exist for a period of time as only makes sense, as long as they're serving at the confidence of the legislature. I think that that kind of frictionless system, which is very different from um, what Madison designed, makes some sense. And I think also maybe, for the same reason, a unicameral legislature is not crazy these days, which obviously removes a little bit of friction if you have only one deliberative body. So I think, just to summarize, I think it depends what you want as a society. And I think those are the trade-offs.
I want to come at it a little more obliquely, I think, or a side element. So you were asking about structure, basically, balance of powers and whether we should modify it. And of course, the situation is going to be different in different countries that have different histories and different needs. So, one of the things, well, what I do professionally, I teach, but in addition to teaching, I'm hired by governments that are writing constitutions or trying to implement treaties that they've signed. And so these are places that are trying to get better government. And the first thought they have is, well, we can have a better constitution or we can have better laws. And I think that's important. That's a sine qua non. If you don't have a well-constructed constitution, it's going to be very hard to have the rule of law. But it's not sufficient. And the biggest and most important predictor of whether you have a well-functioning republic is actually the culture, what people think about the law, what people think about their constitution. And if you can, and it's very hard to think, how do you move a culture that has become very corrupt or corrupted? How do you get the citizens themselves to start thinking in terms of the common good, which is the purpose of the Constitution? And I think that is influenced not just by structures, but it can be influenced by individuals. Individuals can play a big role. In other words, if a leader of a country articulates these principles well, it will move the whole country in a good direction. And that's true not just of political leaders, but also of judges. So when you started out, you talked a little bit about the possible weakness of judges, but their great strength is their ability to articulate well the value of law and principles. So if you have a strong and intelligent and coherent and principled Supreme Court, even in a country where the culture is quite corrupted, the influence of that court can be enormous in moving the culture in a better direction, as happened in our country during the civil rights movement. And I think it can happen in other places too, to articulate well the fundamental values that we share or aspire to share. And in the same way, a bad court or poor judges can move things in the wrong direction, just as bad executives can. So I think that the culture can be moved by individuals who speak and articulate fundamental values well. And that's in addition to having a well-structured constitution. But I think I would differ with Zachary in going towards unicameralism, because I think that drifts often into Caesarism. And so we like power, but I think I like to have those checks. I don't want to have a moment when the population gets carried away and suddenly you have someone who acts in an arbitrary way and has absolute power. And I think that's a danger of unicameral parliamentarism.
Thank you. Zachary, I don't know if you want to comment back on this, or we can.
Yeah, I would just say that I think we agree that it really depends on the characteristics of the society and what they need at the time. And I think I agree that, moreover, that there's a certain danger in imprudent, let's say, hasty and one-sided decision making, which maybe could be more characteristic of a unicameral legislature and perhaps more characteristic of parliamentarism. And what I see in a lot of Madisonian-like governments that are essentially the US and most of Latin America, which has adopted presidentialism, is something which is suffering from the other problem. But I agree that it just depends.
Well, there are a couple of questions that are quite interesting. So one says about that obviously it's important to have implemented constitutions or written constitutions for unity. But then there is another question that says, well, there are some countries without written constitutions like Canada, the UK, and New Zealand. So we have cases in both countries, in both cases, in which both can achieve unity and rule of law. So which speaks about the importance of having a written constitution, and to the points that you were making previously about everybody knowing the rules and so on. Can you comment on this just based on your experience?
Yeah, I guess I'll start if I can. You're right. I mean, everybody thinks about the Constitution as the written document, Alejandro, and people forget that in addition to the large C Constitution, there's this whole constitutional order of things that we think of as almost constitutional, as sacrosanct in some ways, whether that be a really important pieces of legislation, whether that be pieces of jurisprudence and decisions that have been handed down, whether it be just cultural norms that exist in Congress, things like the filibuster. We tend to think of these things as constitutional somehow, and that violating them would be like the nuclear option to do away with an important part of our society. And I think this is what goes on in the UK and other parts that have other parts of the world, very few parts of the world that have parliamentary sovereignty and are not necessarily ruled strictly by a set of documents that are written by previous generations. And I think if you're going to have parliamentary sovereignty and the idea that Parliament can essentially do anything that it wants as long as they have the majority, then I think you have to have some of these norms that are etched and deeply embedded in society. I think that's helpful just for the continuity and maintenance of institutions from administration to administration.
Every state in the world has a constitution because you do things and you do them according to some pattern. So already Aristotle was studying all the constitutions all over Greece and was giving us descriptions. They weren't written, but they all had constitutions. And I think Britain is a famous example of an unwritten constitution that has all sorts of very, very, very firm rules. And similarly, the Constitution of the United States is constantly being amended by the judges. So you have formal constitutional amendment, which doesn't happen very often, but you have informal amendment, which just means they take the words that are in the Constitution and choose to have them mean something different. And that can be a very significant amendment. We're seeing that quite often now. The current Supreme Court is very activist in changing the Constitution, or at least changing our understanding of the Constitution. So I think it's safe to say that the difference perhaps between Britain and the United States is not as great as we think in this respect. And Canada has made an interesting transition from starting out in the British tradition. They now do in fact have a written constitution. And it doesn't seem to me that the behavior of the court is very much dramatically different than it was before. I guess the main thing is that they now are willing to give advisory opinions, which I don't think they did before. But there's a global culture of constitutionalism. I guess maybe this is a way to bring Tariq's knowledge to bear on this, because all these different constitutional courts are reading each other's decisions, and the decisions that you find in India have an influence all over the world. And one of the interesting things to observe is how this changes over time. The United States traditionally had a lot of influence because our court was highly respected. But now I think maybe the Indian or South African courts are having a greater influence. And you see the judges understanding each other, communicating and learning from each other. Some of these things can have application in more than one setting.
Tariq, do you want to comment something?
Yeah, I think there was a question about constitutional promise and how it works in practice, and I thought that would be interesting to kind of reflect on. A lot of the things we've been talking about in terms of Indian conceptions of secularism has been in terms of a theoretical conception of how these ideals are considered. But when they work out in practice, particularly in jurisprudence and when states are enforcing particular laws, we kind of see this kind of distance between what is the ideal at one point where a framer of the Constitution, or where the courts even say that what we're trying to do is trying to have equal respect for all religions. But then at times when there's actually imposed in terms of through law or through judicial decisions, they can be at times differential treatment. And also there's also the question now increasingly in India of how whether something is really motivated by secular reasoning, or is it usually to more majoritarian reasons? Particularly now, we can see on face value a lot of the recent reforms by the Indian Supreme Court in terms of looking at Muslim personal law. You can think of that in terms of there's legitimate reasons for it, for looking at fundamental rights, women's rights. But then at the same time, we can also see other motivations of people supporting those reforms who may have more majoritarian kind of motivations for these reforms rather than actual fundamental rights. So we see that kind of inherent tension within this kind of conception of secularism and how it works out in theory and how it actually works out in practice.
Thank you very much, Tariq. And I'm conscious of the time that we're just approaching the end. There were still some questions that I will leave the panelists to answer. I mean, some of them were indeed just about the data sets just that are available. So I invite you to review some of the websites. But I'm going to just to close, I'm going to pass the floor finally to the Law Librarian of Congress, Ashley Humboldt, who has hosted us. Thank you for having us, and just like to pass it to you.
Thanks, Alejandro, and hi, everyone. My closing will be very brief, so I just want to thank the American Bar Association and our amazing panel for this fascinating and quite thought-provoking discussion. And I want to thank all of you for joining us to celebrate Law Day. We invite you to visit the Law Library's Legal Research Institute online at law.gov to learn more about our upcoming events and webinars. And please visit the American Bar Association at americanbar.org to learn more about Law Day and events that commemorate Law Day. Thanks again for joining us.